as Nigeria's federal government continues to take legal steps towards resolving the dispute between the country and the Chinese firm which seized the presidential jets in France, Michael Audit, Nigeria's former Minister of Justice and Attorney General of the Federation, has asserted that Nigeria has a strong legal basis to reclaim the presidential jets recently seized on the order of a French court. Owonikoko, speaking on our show yesterday, that's Monday, emphasized the doctrine of sovereign immunity, which he believed was the key to Nigeria's case.
Sovereign immunity operates in two ways. What the appeal court in U.S. dealt with was the procedural aspect. I'm afraid when people will say, appeal court say, or U.S. say they can attach Nigerian properties everywhere, I don't think that was his extreme position by those who fight to frighten the country. It has to do, recognition of award has to country by country. When you register, the country will evaluate it. And two areas the country will look at is did the arbitrators who rendered the final bidder award exceeded their jurisdiction, or was the arbitral award contrary to public policy? Nigeria is now hinging on the issue of public policy. That is it. But of course, issue of sovereign immunity. But now where I have a major quarrel with the Chinese people is that the sovereign immunity, even though after the convention, the New York conventions have been classified into two. Absolute sovereign immunity, properties that belong to the state which the state uses for operation of state, not for commercial basis, are immune. They are considered sovereign immunity. For instance, military hardwares, presidential planes, because presidential planes are not used for commercial purpose. Presidential planes are used basically for state functions, and those ought to enjoy absolute sovereign immunity. Sovereign immunity, which I am afraid I don't understand the basis in which, especially like money in the treasury.
Joining us now for more clarification on the matter is Abiodun Owonikoko, a senior advocate of Nigeria. He'll be reacting to the legal feud between Nigeria and a Chinese company which currently seized Nigeria's presidential jets in France. Good morning, Mr. Owonikoko. It's good to see you in the studio.
Good morning.
Great to have you.
Welcome, sir. Welcome. Very welcome.
But we've been enjoying you all this while.
Thank you.
Excellent. Thank you. Now, yesterday's interview, I don't know if you followed the interview with Mr. Owonikoko, and he explained a few things. I don't know if you agree with it. Let's start, first of all, with the fact that he said that the Chinese company should not seize the presidential jet as a result of the fact that it's not meant for commercial purposes. It's used for state business. What's your take on that?
The truth is that people are confusing right to enforce judgment when registered with target of enforcement. Under the sovereign immunity principle, there are certain acts that are acts of state. That's just a simple explanation. Acts of state, acts conducted for running governance. Because there is principle of equality of state. Each state must treat the other with the same respect and dignity. Now, we are a government, especially Nigeria in the 90s, 70s, up until 2000, was running a command economy. A lot of our businesses got entangled with government involvement. So certain assets of government were classified as commercial assets, even though owned by government. The unfortunate thing is that the leading case on this matter actually generated out of a controversy between foreign investors and Nigerian in the 70s during the Amada cement crisis. Yes, you have all these Trenters and CBN cases where the UK court and even the US courts, you have several of them, CBN, federal government.
Lord Daddy even ruled us
exactly. Now stated the principle that where government dabbles into commercial transaction in such a way that it's impliedly decided to engage in business, it cannot be immune from the consequences of breaching the contract. Now, in a situation involving the Chinese, people have forgotten that Nigeria and China has a BIT, Bilateral Investment Treaty, which was signed in 2001 and came into force in 2010. Under that agreement, foreign investors from China who latch onto that treaty are entitled to some form of protection for their investment. And so if there's a dispute, there's provision that they either go to Nigerian court or they resort to arbitration. In this particular instance, the Chinese company decided to go to arbitration. Usually, it's the safer bet for foreign entities in a country where they want to protect their investment. So where we are now, the assets reportedly attached in France are federal government public presidential jets used for running government business. But if it was a CBN private jet being used for commercial transaction, it probably would not be as protected as a presidential jet. So I see the issue involving those jets as not really a matter of enforcement of judgment, but a diplomatic issue.
So let's say they weren't able to take the jets. What other choice would they have? Would they have been able to come into Ogun State to come and seize assets for breach of the contract? What other choice did they have at this point?
Now, that's why I referenced the BIT.
Yeah.
Any foreign investor in Nigeria that decides to take advantage of the BIT will be entitled to go after the federal government for any investment decision that prejudices his interest in Nigeria, so long as it's covered under the BIT. And the BIT Nigeria has with China covers fairly a broad spectrum of businesses. Most of them, and that's why I'm worried by the fact that, we have proliferation of export possessing zones now.
Yep.
We have almost 30-something.
That's correct.
Go and some of them are in Kano, some of them are in Kogi, some of them are in Kaduna, and you wonder what we are exporting.
Yes.
Under the NEBSA, the 1% of businesses covered by export is agriculture. Only 1%. And this is about the only thing I know Nigeria presently has capacity to export. So a lot of businesses that are coming into those zones are protected by the BIT. And most likely, in an era where companies are exiting because they are not comfortable with their business environment, those that will remain are those who are protected in those zones. And they are likely to initiate dispute resolution through arbitration so that they can go after federal government for all kinds of liability that may arise. It's not only state versus state. Even liabilities arising between them and co-Nigerian investors can be subject of those proceedings.
Really?
Yes, yes.
So isn't it time, with due respect, to review that bilateral trade, treaty we had? Because that's very suspect. At first, it gives them the upper hand against us in Nigeria because we are not meeting our own end of the bargain because of lack of productivity and all of that. Secondly, let's talk about the flimsy way these state governors do all sorts of written agreements. Yesterday, I asked a question. I said, why Ogun? Because the governors can come out and say, oh, these Chinese companies are scammers and this. What about Olokola? That happened in the same Ogun. There was supposed to be a partner between Ogun State and Ondo government. We saw how the same Ogun State government botched it. And thirdly, isn't it time for our very good friend and brother, Attorney General Lateef Fagbemi, to call all the state Attorney General and say, please bring your books. Let's see it. Because this embarrassment is already on us.
A very valid point. And I think I was on a program, I don't think it was Arise, another TV station, after the PNID judgment. You see, we escaped a big bullet in that matter. And the Nigerian way of doing things is that once we escape one problem, we don't draw the right lessons. I then advocated that there should be an audit of all foreign-related commercial transactions in which subnationals in Nigeria are involved, so that we can anticipate these possible areas of dispute, and the ones that we know are bad, we can negotiate our way out of them before they become enforceable judgments. And I remember, to be fair to the Honorable Attorney General, one of the committees he set up upon assumption of office was one where they were to review all our BITs and then come up with a form of standard agreement which states that want to contract with external investors will have to at least adopt to an extent. And I believe part of what should happen, if they already have that standard agreement now, they should use that to input into our BITs and review. Because all the BITs normally have provision for review, constant review. You request from the other side that you want to review based on either changes in your own legislation or the economic realities. And then you can negotiate yourself out of some of the onerous clauses in those agreements. The problem I have is that Nigerian subnationals, because of the policy of the economy, the easiest way for them to access free money is this so-called foreign investment.
Right.
You can easily determine what comes to them by way of FAC. You can determine what is generated internally, but you cannot determine how much fund they come by way of FDI, which can be misapplied. So in this situation, we have spent our past, we are borrowing into the future against the interest of the incoming generation. This is the time for the federal government, because you can't contract a foreign loan without involvement of federal government. So there is a need now, actually, for more than just ordinary policy. There should be a legislation that will regulate involvement on state enterprises with foreign investments. I'm not talking about Mobile entering into contract with Oando. I'm talking about a state entity in Nigeria entering into a foreign direct investment arrangement with a foreign country, with a foreign entity with which Nigeria has a BIT, which means that we have an obligation to protect that investment and we should give them equal treatment. And one thing that worries me about this particular award is this. The $70 million award, I wouldn't know how they came about it. I don't know how Ogun State defended it, but I'm wondering what was the currency of the transaction?
Yeah.
If it was about losing investment opportunity in Nigeria, it should have been costed in Naira. What the BIT guarantees you is convertibility of any of your returns or gains, not for you to go and claim that you have lost $50 million or $70 million in Nigeria, because there's no business that generate dollars in Nigeria. They should have made their claim in Naira, and when the award is made in Naira, they can then be entitled to free convertibility to remit. Yeah. But it looks like they actually went ahead and claimed the money in dollars in the first place.
Just 1 second. Isn't that to protect the investment of that? Because look at what's happening with the currency. If your currency continues to depreciate, you will want to cost it in dollars so that you make sure that you convert it in Naira at the prevailing exchange rate to get your FX back. Is that not a risk?
I'm happy you are saying that you are a financial person. There is something called forex risk management. If you know that the Nigerian environment does not allow you to cost, you have provision in the BIT on your contract to say, when you now make your claim, you have to justify that the loss you have recorded in dollar value, this is what it comes to. But you can actually test it by knowing that what are the opportunities, business opportunities you have lost in Nigeria that will have done to $70 million. Right. If they had awarded them, for instance, 20 billion naira, it will have looked a lot of money, but it will have been fairly referable to the kind of loss there, because I heard these people have just put up fence and all the rest. Equipment have not come. Yeah. And because we thought we escaped with P&ID in terms of the humongous amount of money that was awarded, we thought that's always a base on which you can resist. That should have been a defense to set up when the arbitration was going on, to challenge the basis of their claim. Even if you are liable, you can challenge the volume, the amount of damages they were entitled to. I'm not too sure how that went. That could have given us, I mean, look at $70 million today. Yeah. Given what you are saying, compared to maybe 3 years ago, it's almost 3 times what it was on the books of the state.
All right, let me go back to the comment you made about when states enter into contracts and that they must seek at least some kind of guidance, or at least inform the federal government, because at the end of the day, as we've seen play out here, the federal government has to pay in this instance.
Exactly.
Would that not be overstretching or encroaching on the sovereignty of states in terms of the federalism of Nigeria? Nigeria. So that's one, because I want you to look, because why should I as a state, what if remember what happened with the previous administration when President Tinubu was governor of Lagos State, and the challenges he had with another party being at the center, and the challenges they had, would politics not come into play at that level, and would it not be encroaching? That's one. The second part is that I want you to throw a bit more light, because yesterday Mr. Owonikoko talked about jurisdiction. He also talks about if there was there's a provision in the treaty around there must be options settling locally through the courts locally before approaching a foreign court. Would that be basis for merit? Because what the presidency released a statement, and what they said is that they held the Chinese company held back some material facts from their case before the judge, and that they were not even served. As Ogun State wasn't served, they were not put on notice, and so they were going to appeal this court. Is there merit in that statement? Yes,
CBC. I think we should be careful. There is already a resolution of dispute by an arbitral body. Yeah. The question is not whether you are liable or not, until you cannot appeal an arbitral award. You can only resist the enforcement. What they are referencing has to do with the judicial proceeding for enforcement, that's not arbitration proceeding. That's post-award proceeding. It's a litigation thing. So if you are seeking to enforce an award, you also have a duty to make an open disclosure of all relevant facts. I don't know how they represented those jets that enabled the Paris court to give the order it made. It's possible they suggested that those jets were being used for commercial purposes. It's possible, but to the real issue you have raised, a country has only one sovereign. Subnationals are not sovereign, number one. Number two, under the Constitution of Nigeria, foreign commerce, foreign debt are all matters in the exclusive legislative list. So if the leverage granted to states, subnationals are being abused to incur liability on the entire federation, there's nothing stopping the federal government from legislating to regulate that. And I'll tell you why. Even in the US, the Foreign Immunities Act in US was in 1976. Before then, it was a matter for State Department to decide whether they will allow a state to raise immunity as a defense to a suit in the US. When they saw that the thing was becoming unpredictable, there was too much uncertainty, they had to enact a law that streamlined what Abiodun was referring to now, what they call restrictive immunity. If, like I explained, if it's a matter that has to do with normal government function, unless you can show some element of commercial interest of a company that has some effect in the US, you cannot sue the foreign entity in the US. So they now made that law, which now clarified the position. So Nigeria has got to a stage now where we need to enact a law, and that law is what will enable us negotiate the terms of our various BITs now. Because BITs are meant, even the BITs, they are treaty until they are adopted by National Assembly, they are not effective. So it shows to you that if there is a local legislation that says this is how foreign bilateral investment treaties should be negotiated, these are the terms on which you can proceed. You can clearly say, look, these particular assets are not available for enforcement in your law. And they enter into a treaty that incorporates that law, then it will be very clear. It will be a lot easier to resist such enforcement.
There's the jurisdiction issue that Mr. Owonikoko raised. Is there any merit to that?
Well, you see, in terms of jurisdiction, once, in fact, people don't know, it's only arbitral award. If you have a judgment against the Nigerian government, and have been involved in one, you can actually assign that judgment to a foreign entity for the purpose of enabling you to enforce it outside of Nigeria. I've been involved in one, as well as 2001. And it was enforced. In fact, Andoka Attorney General was on seat when we came to negotiate settlement of that matter with the federal government. And the American consulate had to attend because the judgment creditor was an American company. It was only assigned the judgment debt.
And that's noted. But for the sake of education, you said, what's it called? The state is the most sovereign. So the local, the subnationals.
They are subsumed in the state.
They are subsumed in the state.
Internationally, they only recognize Nigeria.
But was that the case in the 63 Constitution?
Yeah, you see, what happened in the 60 Constitution, it was 63 Constitution that moved us to the Republican era. But under the 1960 Constitution, the regions had consulate, they
even
had
abroad.
Consular presence abroad.
Yeah, that's because that's why I didn't really ask that question.
But it did not make them sovereign.
So the regions were not sovereign?
They were not sovereign.
Okay, but they just had consular representation.
Yes,
because
it was negotiated that they would give
Northern
them
Nigeria.
Yes.
If we had a confederacy, would the regions have been sovereign?
No, that would have been a different thing. That's why people don't want the confederacy in Nigeria.
Okay, so if we had a confederacy, the states would have been independent sovereigns within the states.
It would be a supranational.
Okay.
Nigeria will be a supranational where each of them will still be regarded as
national. Second question is, what should we have learned from the Cement and Mother case in the 70s that we did not learn, that is still biting us today?
The first thing is that in the 70s, Nigeria was awash with money. So this was not a threat at all. It's not as even if you got judgment, we didn't have money to pay. In fact, we were willing to pay anybody any kind of claim in those days.
But the claim payment sank us. As at 83, we had already tipped into a recession.
Because by 1983, economy was on down. In the 70s, when those cases, we had awash with money.
Yeah.
We were importing everything. So, but where we are today is that, like I said, the fear I have now, the freest money available for state to waste is no longer money generated here, but for foreign investment that they can attract under the cover of state protection. And that's why the monies are being frittered. So it is high time federal government intervene with the legislation, not to constrict, but to make it, to create a responsible process by which subnationals can access foreign direct investment in such a way that they can get value for the money.
Can we also check projects like ports? Because we are seeing a lot of Chinese interest in ports, and this new madness, a lot of state governors are doing now, airports everywhere. They're getting a lot of foreign. Should we also take a look at those projects?
No, it's not. You see, what I'm saying, I'm not trying to constrict the independence of judgment by states. In fact, give them as much freedom as possible, but create room for accountability so that there is a clear process that you know that anything you are going to do that involves foreign investment or foreign loan, there is a procedure we will check to ensure that Nigeria is getting value for money. And it will be transparent, you know, that even your own locals, your House of Assembly, everybody will have access. There should be, what I mean by that is that there should be a register. In fact, if you look at what's happening now, it's very dangerous. Former Governor Mosu came up with his own explanation.
Yes.
The Ogun State came up with his own. Bengadania came up with his own. I read the foreign minister also speaking in Equatorial Guinea, giving a different account. All of these are not going to be helpful to you in a court where we are going to challenge these matters.
Do you think they can use those differences against us?
Of course, because they are all functionaries of government and they are speaking different languages. Yes. And I see the foreign affairs minister identifying a loophole where he said that the problem is that these states were doing these things on their own without reverting to either foreign office or attorney general. So that shows you there is a lacuna in the system that we operate now.
So that statement would be used against us. I felt that maybe it was a slip. That when he spoke,
he shouldn't have said that outside of Nigeria.
Saying that the challenge is that, and that's why
because you are admitting that it was our error.
Yes.
Wow.
Yes.
Well, but from the beginning, wasn't it clues that it was our error?
No. You see. As a lawyer, until you test it in court, you cannot be too sure of what is your strength. Yeah. So, but for somebody of that status to come out and say this mistake is a problem for us, you understand? And that's why, you see, we escaped P&ID because at that time, if you look at most of the awards that we successfully defended, we lost arbitration on Bakassi because he made it a local affair. Nigerian lawyers were asked to go and in P&I, they had to change lawyers to one of the biggest and best in the whole world. And they also needed support of the Nigerian state institution. They had to do investigation on how those transactions were going and found a lot of things that supported the case of fraud. Because fraud is one of the easiest way, one of the most difficult but most assured way to overcome an arbitral award. It's difficult to establish.
But Governor Mosu said he will work with the Nigerian government to prove that there was fraud.
I'm telling you that it's too late.
Really?
Yes.
Because it's an arbitration, as it mentioned.
Award has been granted now.
It's arbitration. It's already.
And it was granted.
No, you see, but the thing is that challenge of arbitration award is time bound as against resisting enforcement.
But P&ID too was granted. I want to learn from you.
In P&ID they had to ask for extension and justify the extension. They had to be finding out why was it that there were issues in the bureaucracy that Attorney General did not give approval for some witnesses to testify, and they didn't know whether that they didn't engage lawyers within time because there were provisions. They showed that they made effort in-house, but there was some bureaucratic bottleneck that prevented from acting with them. So they gave them extension, which is not usually granted. But
can we get extension in this one?
Well, it's possible. But what I'm saying that for now, the president should ask everybody to hold their sword. They should stop talking. From now on.
From subnationals to
federal level. They should not even say anything at all now. But because everybody wants to justify himself, it was in my own time, I did the right thing. Nobody seems to think that there is a greater national interest involved at stake.
So I was just going to ask in terms of, so yesterday we asked a question around what are the options available for Nigeria? Do we have a case? Which Mr. Audit feels that he believes strongly that Nigeria still has a case in this matter. You don't sound as optimistic.
No, about the enforcement against the vessels.
Yeah, well, even the case to appeal.
You don't appeal arbitral award.
Maybe to challenge it or to ask for an extension.
Yeah,
he seemed a bit more optimistic about that.
I don't know the full facts. I don't know the full facts, but so far, the limited window to challenge an award is either fraud, excess of jurisdiction, or public policy. You understand? On public policy, I'm not too sure, given what these people are saying, that you can get out of it, because you have already considered here that it was their own mistake. both the sitting governor then, the subsequent governor, and I also saw some things I didn't understand.
He didn't admit to.
No, I'm talking the foreign affairs minister said it's a mistake that the thing should not.
Yeah, that's it. But Amosu Angbenga said.
But his own evidence is the most damaging because he's the representative of the federal government. Amosu is no longer a sitting governor. Anything he says can be taken as a private opinion. But for the foreign affairs minister to say that the mistake came from the governors not passing through the relevant federal authorities before they went and made the commitment, I wouldn't know how that happened. And in this case, I would suggest, like I've been saying, that look, this is a matter that should be approached from two angles. And I think government is doing that. Diplomatic side and the other side. But let me tell you, there are things we don't do here. There's economic intelligence that we don't apply. If Chinese entity has a claim against you in Nigeria, the Chinese authorities support them. Even if they need evidence of fraud, they will assist them to get that evidence.
Right.
Because they are very mindful of corruption in China. Things that you go to court here and get away, they will execute you in China as a government official.
Yep.
Quick question. Do you understand?
Should President Tinubu, after his stay in France, go to China and go and sort out this out diplomatically?
Well, I think there are too many things involved in the office of president that I can't tell what is the
No, but I think with what you have said,
yes,
he should be on his way to China after whatever stay he's going to have in France to go and sort this out diplomatically.
I'm not sure he needs to physically go.
Yeah, that would be...
There are levels of diplomatic arrangement that will have to be involved in the state visit. So many things are involved.
So the
Minister of Foreign Affairs, probably the Attorney General. They can start, and I'm sure they are doing something about that now. But it's not something to wait
So
over.
this list back of our jets that they're giving us now, because even the jets, we've not even talked about how they bought it, how they made budgetary appropriation for it, and you were saying we don't know why it was being deemed as probably a business commercial, because we don't even know how they bought it. We don't even know if they sold two jets to buy it, because if they sold two jets to buy it, then there was a business transaction involved somewhere. They've not told us anything. And these are the questions we keep asking Mr. Bayon Onuga, because after bragging about the brand new jet yesterday, he didn't tell us how they get the money to buy it. As a sovereign, we have a right to know. The question will be, is this list going to be permanent? Because now they have listed back to us, at least for the president to take it to France. Will they leave it with us? Will it settle with the French courts? Will it go to China? Or after the president finishes this trip, they will say he should go back to the niche that the plane was coming from?
Well, you see, one of the things, that's why I expressed my skepticism. If this vessel is under the process of acquisition, it's not yet a presidential jet. If it's under a process of acquisition, they are trying to buy it under some form of arrangement. It's like a product. It's not a military jet, which is one of those other things that are immune. If you are just trying to purchase a jet, and they found out you are a judgment debtor as a Nigerian entity, it is not yet designated as presidential jet. That may be a problem in terms of asserting immunity over it. The moment it starts flying as presidential jet, it will carry the Nigerian...
It flew yesterday like 418.
But you are saying maybe there's a lease back temporary. I don't know what kind of arrangement.
No, because they said they were going to give the jet back for President Tinubu to fly to France as a result of goodwill. That's what Chinese companies say.
That would not change the character of the plane as at the time it was attached. Yeah. If it was not yet officially designated as a presidential jet, it might actually be open to attachment, which is all the more reason why there is a room for diplomatic resolution of this matter. But beyond that, Nigeria needs to go and do audit of all its BITs and then review and introduce clauses that will at least prevent the government as a whole being embarrassed and then being exposed to what we call some of these windfall arbitral awards. Arbitral awards can be at large.
Yeah.
You understand?
Okay.
And you can get 1 billion or 2 billion before you know it. We are struggling to pay another set of...
But at the end, look, you made a very crucial point earlier on, saying that right now, with where the economy is, we need foreign exchange so badly. Right. So, with wherever you want to go with all these agreements, they will always favor the entity that is bringing the money in here, right?
Sure, but see, you can still negotiate them better than what we have now. I don't see why somebody will be putting up fence. You understand?
Yes.
And then based on that, you go and make a claim and get $70 million against Nigeria. Sometimes I watch you every time. Sometimes if our forex rise by $40 million. Sometimes you celebrate it on your program.
Yes.
Just $40 million,
Right.
maybe over a week when we are checking. So $70 million just for an unknown quantity with no value is a big dent on our reserves.
So
Indeed.
in terms of punitive, I always talk about punitive measures to deter in the future. So Ogun State, and I'm not, with due respect to them, what then happens to subnationals like this who put Nigeria in the pickle? The tenure is over, but is there anything that can be done, or would they just go scot-free? Those who are found, if they are found complicit, those who are found dereliction of duties, would there be anything, or they just go scot-free after this?
Now, you see, from what we see here, really, it was a kind of political decision that led to this trouble. So I've not yet seen evidence of corruption or fraud in what has happened. It's purely politics. And you don't try people for political mistakes. The only thing is that if you dig deeper, what looks like ordinary political decision may actually have some element of fraud. In which case, when you leave office, immunity will not cover fraud.
Yes.
So, depending on from Governor Gbenga Daniel, Governor Amosun, and Governor Abiodun, depending on maybe not themselves, maybe functionaries under them who advise and midwife this transaction might, like nobody ever thought that in P&ID, people in Ministry of Petroleum, NMPs were collecting money here and there. Some of them as ridiculous as £10,000, all those things. You understand?
So
and then they expose the whole country to $10 billion.
So further investigation.
Yes, it may be warranted. But not only that, all those other transactions that the various subnationals are engaging in, trying to get foreign exchange, government should beam its light, EFCC should beam their searchlight on them now. Once they know there is interest, I think there will be some form of deterrence.
Very good. Thank you so much.
Thank you. Very informative
Mr.
conversation.
Owonikoko,
Really
for your
appreciate
time.
it.
Very apt as always.